college has been recognized by the UGC as college with potential for excellence and also accredited by the NAC. Since its inception, is trying to search for innovative methods in implementing legal education and attract students from all over the country and also from abroad. The Neeti Forum is constituted as a part of our IQAC initiatives with the objectives to have knowledge-based initiative to strive the students, faculties by efficient and accessible administration of knowledge for all. Through this Neeti Forum, so far we have conducted several special talks, webinars by inviting distinguished judges and eminent speakers on various topics. To quote few, firstly, the Neeti Forum was inaugurated by Honorable Justice Puri and Joseph. Later, we organized several seminars and special talks by inviting Honorable Judges of Supreme Court and High Court. Firstly, Honorable Justice K.T. Thomas, he spoke on constitutional perspectives of secularism. And subsequently, Justice Chalameshwar, he spoke on rule of law, and on RTI, Mr. Sjslc Singh, and on the topic rule of law and human rights by Justice Chandru, and on the topic judicial review in democracy by Justice Devan Ramachandran, on the topic constitutionalism by Justice G.S. Singhvi, and about the consumer protection by Justice R.K. Agarwal. Very recently, Honorable Justice of Supreme Court of India, U.A. Lalit, he has released a book titled Momentous Challenges of 2 Decades, written by Justice K.T. Thomas. Now, today, we have distinguished guest is our former Judge of Supreme Court of India, Honorable Justice A.K. Ganguly, sir, who is going to enlighten us on the topic public interest litigation and the Supreme Court. Honorable Justice has delivered several landmark judgments. Justice Ashok Kumar Ganguly is a well-known jurist. He served as the chairman of West Bengal Human Rights Commission and as a judge of the Supreme Court of India, who delivered judgment in some high-profile cases like 2G Spectrum case. The details of his lordship achievements and biodata will be briefed by our student, Mr. Suryadev, shortly. When we requested his lordship to be the guest speaker and address our students and faculty, and he has wholeheartedly accepted our invitations, and he is with us. Sir, on behalf of Jsslc Law College, Neeti Forum, and on behalf of all my staff and students, I extend a hearty welcome to you, sir. I also extend a warm welcome to our Professor K. Suresh, Chief Executive of our college, who is guiding us in all our programs. I welcome you, sir. I also welcome all the faculty members of our college, students, and the members of the Neeti Forum, and especially all the invitees who are present through online. Lastly, I extend a warm welcome to one and all. Thank you.
Thank you, sir. I now call upon Mr. Suryadev to introduce the guest to the audience.
Good evening, everyone. I, Suryadev, consider it a great privilege to be given this opportunity to introduce Honorable Mr. Justice A.K. Ganguly to the audience. Ashok Kumar Ganguly was born on 3rd February 1947. After completing MA in English in 1968 and LLB in 1970 from Calcutta University, he was enrolled as an advocate on 1st December 1971. He started his practice in Calcutta High Court and also in Supreme Court of India in constitutional, service, labor, company, education, revenue, customs, and various civil and criminal matters. He was elevated as Chief Justice of Orissa High Court on 2nd March 2007, and he was transferred to Madras High Court as Chief Justice on 19th May 2008. He was elevated as Judge of Supreme Court of India on 17 December 2008. Some of his lordship's notable judgments are the 2G Spectrum case, where on February 2012, a bench comprising of his lordship and Justice G.S. Singhvi quashed 122 2G licenses issued in the year 2008 by terming them as unconstitutional and arbitrary. In Rajnath Chauhan versus Banikant Das and others, Justice A.K. Ganguly observed that in 1975, during the emergency period, Supreme Court of India had violated the fundamental rights of Indian citizens. The bench of Justices Aftab Alam and his lordship took the view that the majority decision of a 5-member constitution bench upholding the suspension of fundamental rights during the emergency in ADM Jabalpur versus Shivkant Shukla was erroneous. On President's pardoning power, Justice Ganguly made it clear that the President or the Governor exercising the power of pardon in granting remission of sentence to a convict could not encroach into judicial domain and giving a finding on the guilt of the convict. If such a power was exercised arbitrarily, nullified, or in absolute disregard of a finer canons of constitutionalism, the byproduct order could not get the approval of law, and in such cases, the judicial hand must be stretched to it. On personal liberty, he said that in preventive detention cases, the representations received from the detainees must be disposed of expeditiously, and every day's delay must be properly explained and accounted for. The representations should be very expeditiously considered and disposed of with a sense of urgency and without any avoidable delay. His Lordship retired from Supreme Court of India on 3rd February 2012, leaving an incredible imprint as a bold and courageous judge. He was a chairman of West Bengal Human Rights Commission as well. Today, Jsslc Law College and the Neeti Forum feel honored to have His Lordship with us. Thank you.
Thank you, Surya. Without any further delay, may I now request His Lordship Mr. Justice A.K. Ganguly to address the gathering with his valuable words.
Thank you and good evening to all of you, the members of the faculty, the dignitaries of the college, and my dear students. I feel privileged and honored of being called upon to give this talk on public interest litigation at the request of Jsslc Law College, which is, I understand, one of the biggest autonomous colleges in this country. And these are called Neeti talks. Now, before going into various provisions of the Constitution, if I may just explain that every litigation in which the government is involved has a public interest in it. Reason is this, that under the Constitution, we have a list of, we have the Charter of Fundamental Rights, which is known as Bill of Rights. The Constitution is written. Under the Constitution, the role of the judiciary, the role of the executive, the role of the legislature is clearly delineated. Now, if I may just explain to you what are their assigned roles. Under the Constitution, the legislature is not supreme. It is controlled by the Constitution. I will explain to you where it has its limitations. First of all, Article 13 says, Article 13 is a fundamental right. It says that the state cannot make any law after the Constitution has come into force, which will take away or abridge our Part 3 rights, that is our fundamental rights. Now, what is Part 3 rights is not static, it is constantly expanding. The width and ambit of our fundamental right is constantly expanding. Therefore, while making laws, the state, that is the parliament or the state assembly, must be aware of the ambit of fundamental right. If it makes such a law, what will happen? The law which is inconsistent with Part 3 rights will be declared void. Now, who can declare it void? It is only the jurisdiction of the judiciary to declare it void, because the legislature cannot declare the law void, nor can the executive declare the law void, because the executive under our Constitution is a limited authority. Limited authority in the sense its power is limited by law. Everywhere it is said, the power of the executive extends to the area where there is a law. The executive under our constitutional position cannot act without any law. Therefore, the first duty of the executive is to protect the rights that is protect the fundamental rights of the citizen. When there is an infraction, people go to court. And when people go to court alleging any infraction of the rights of the people by the state authority, whether it is executive, whether it is legislature, it is duty of the court to examine it. And there comes an element of public interest. Now, I should say that even today, even in litigation where state is not involved, suppose in a litigation between husband and wife, the state is not involved. Even then, there are elements of public interest in it. Say, for instance, a wife's plea for maintenance, plea for custody, where a student wants admission in a college, which is not a government authority. There are also public interest involved because his right to education, his right of development, which is a fundamental, is involved. Therefore, public interest today is a growing concept. Why growing? Because of a growing assertion of individual right, a growing awareness of your right. This growing awareness of your right, the legislation which is made by the state in affecting various aspects of human life, these are connected issues. Therefore, there is a process of democratization of right. Right regime is ever expanding. In that context, public interest litigation assumes great importance. Now, public interest litigation is a species of judge-made law which evolved out of the constitutional provision, which I will explain to you. We will first start with the preamble. Our preamble says that we, the people of India, have created a state. What is the character of the state? It's a sovereign, democratic, socialist, secular republic. And the state ensures the first guarantee which the states give in the preamble is that it ensures to all its citizens justice. Justice to the widest variety. Justice in all its facets, social, economic, and political justice. Now, therefore, here it is the state's responsibility to assure justice to its citizens. And which is the state? You know, the state has three limbs: the legislative wing, the executive wing, and the judicial wing. So therefore, judiciary is a part of the state. I shall explain to you from the provisions of the Constitution. Judiciary is a part of the state. This is very clearly stated in Article 38 of the Constitution. If we look at Article 38 of the Constitution, and permit me to read it to you, the provisions of Article 38. It's a very, though it is in the chapter under directive principles of state policy, but it is a very important article. What does it say? The state shall strive to promote the welfare of the people. It's a welfare state. Our state is a welfare state. Strive to promote the welfare of the people by securing and protecting as effectively as it may a social order. Can you look at this? In which justice, social, economic, and political shall inform all the institutions of national life. The same words of the preamble are quoted here. Justice, social, economic, and political. Therefore, it will be the perpetual effort of the state to promote a social order, which means the effort, it should be the effort of the judiciary also, not only the legislature and the executive. It should be the effort of the judiciary also to promote the welfare of the people by securing and protecting as effectively as it may a social order, just social order. That is possible only through public interest litigation. And I will also request you to consider this article was considered by this article and Article 37. Look at what Article 37 says. The provision contained in this part shall not be enforceable by any court, but the principles therein laid down are nevertheless fundamental in the governance of the country. Very important. And it shall be the duty of the state. Duty of the state means duty of the judiciary also to apply these principles in making laws. These provision not only does cast an obligation on the legislative wing of the state to make laws, but Justice Matthew in Keshavananda Bharati's case has held, it is the duty of the judges also, while delivering judgments, consider these principles in delivering judgments, in making laws. Because you know the judges of the Supreme Court, the highest court of the land, they declare laws under Article 141, and which is made applicable to all the courts in India. They lay down the rule of law. Therefore, you make a combined reading of Article 37 and 38, then you'd find that it is one of the obligations of the judiciary to make such judgments which will create a just social order in which all institutions of national life shall be informed by principles of justice, social, economic, and political. And for that reason, you kindly see, I shall read out a few passages from Justice Bhagavati explaining these provisions. Look at Article 39A, which came by way of amendment, 42nd Amendment. Very important. The state shall secure that the operation of the legal system promotes justice. It is not the rule of law during the British regime. So during the British regime, we also had a rule of law, but that rule of law was maintained to ensure the status quo. Our masters, the colonial masters can rule. They can maintain their hegemony. It is not that rule of law. What says it must promote justice, which is much more than rule of law. Justice means justice of the widest dimension. Where the state shall secure, here also the state, which includes the judiciary, shall secure that the operation of the legal system promotes justice on the basis of equal opportunity, and shall in particular provide free legal aid by suitable legislation or scheme or in other way to ensure that opportunities for securing justices are not denied to any citizen by reason of economic or other disability. The poor people should not be wished away from court. The doors of the court should not be closed to them. In this context, I would just read out to you very important observation of Justice Bhagavati, as his lordship then was, in People's Union for Democratic Rights and Union of India. I'm reading out. The rule of law does not mean that the protection of law must be available only to an unfortunate few, or that law should be allowed to be prostituted by the vested interests of protecting and upholding the status quo under the guise of enforcement of their civil and political rights. The poor too have civil and political rights, and the rule of law is meant for them also, though today it exists only on paper and not in reality. This is the comment by the great judge, Justice Bhagavat. If the sugar barons and alcohol kings have the fundamental right to carry on their business and to fatten their purses by exploiting the consuming public, have the chamars belonging to the lower strata of society no fundamental right to earn an honest living through their sweat and toil? So far, the courts have been used only for the purpose of vindicating the rights of the wealthy and the affluent. It is only these privileged classes which have been able to approach the courts for protecting their vested interests. It is only the moneyed who have so far had the golden key to unlock the doors of justice. But now, for the first time, the portals of the court are being thrown open to the poor and the downtrodden, the ignorant and the illiterate, and their cases are coming before the courts. The time has now come when the courts must become the courts for the poor and the struggling masses of this country. They must shade their character as upholders of the established order and the status quo. They must be sensitized to the need of doing justice to the large masses of people to whom justice has been denied by a cruel and heartless society for generations. The realization must come to them that social justice is the signature tune of our Constitution, and it is their solemn duty under the Constitution to enforce the basic human rights of the poor and vulnerable section of the community and actively help in the realization of the constitutional goals. This new change has to come if the judicial system is to become an effective instrument of social justice. For without it, it cannot survive for long. Fortunately, this change is gradually taking place, and you see here what the learned judge said. Public interest litigation is playing large part in bringing out this change. It is through this public interest litigation that the problems of the poor are now coming to the forefront, and the entire theater of the play is changing. It holds out greater possibility for the future. So this is the genesis of public interest litigation. And our Supreme Court, I shall have shown to you some provision. I shall show to you the most important provision, one of the most important provision in the Constitution, which is Article 32. Article 32 is itself a fundamental right. You have to, I shall explain to you Article 42 and its various facets to show what was the idea of the framers in framing this. You look at Article 32, it has 4 parts. All the parts are very important. I'm rereading. Kindly mark these words. The right to move the Supreme Court, because each word of the Constitution is very important. The right to move the Supreme Court by appropriate proceedings for the enforcement of rights conferred by this part is guaranteed. No other fundamental right has been conferred in such absolute terms. You look at the other fundamental rights, there are exceptions, there are riders. But this fundamental right is Article 32 itself is a fundamental right. Right of enforcement. Here the right to move the Supreme Court by appropriate proceeding for the enforcement of the rights conferred by this part is guaranteed. This is a guaranteed right, not to be trifled with. Come to 2. Article 32(2), the Supreme Court shall have the power to issue directions or orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, certiorari, whichever may be appropriate. Whichever may be appropriate. There is a great deal of flexibility in this for the enforcement of the rights conferred by this part. That means the main purpose of Article 32 is enforcement of Part 3 rights. And 3 is very, very important, which is hardly noticed. Kindly see what was the idea of the framers. Without prejudice to the powers conferred on the Supreme Court by clauses 1 and 2, which I have read out. Parliament may by law empower any other court to exercise within the local limits of its jurisdiction all or any of the powers exercisable by the Supreme under the Constitution. So therefore, under Article 32, these 32 provisions can never be suspended, even by 359 notification of the Constitution, even during emergency. So far as enforcement of rights under Article 20 and 21 is concerned. To understand the magnitude of the importance of Article 32, that is why Dr. B.R. Ambedkar, at the time of participating in the Constituent Assembly debates while this article was being drafted, said, this is the heart and soul of the Constitution. For very good reason. This is an article which has given you right. It's a fundamental right in absolute terms. The language is the enforcement of right conferred by this part is guaranteed. That is why Article 39A has been framed as directive principle. 39A says that I'm trying to explain to thereafter I'll take the question. 39A says that the state shall secure that the operation of the legal system promotes justice. It is for this reason, Article 32, Subarticle 3 confers the Parliament with the authority to empower any court, anywhere in India, need not be High Court, with the same power which Supreme Court has under Article 32, Subarticle 2. Why not file a public interest litigation for that purpose? Because it's very difficult for people in the far corners of India to come to Delhi for enforcement of their fundamental rights. There is a provision under Article 32(3). Why not Parliament make a law? 226 is given. Look at the opening words of Article 226. Notwithstanding anything said in Article 32, 226 it gives the state high court's power. But even a district court can be empowered under 32(3) to act as a court for enforcement of fundamental right. Because the framers wanted the fundamental right to be enforced. That is the constitutional governance. That is how they framed the preamble. And now today, your preamble is a part of the constitution. Previously, it was thought in Birdwari's case, the preamble is not a part of the constitution. Today, it is said preamble is a part of the constitution. Not only that, you must interpret fundamental rights through the prism of the preambular vision. Therefore, in that context, 32, I have read out to you Article 37, Article 38, Article 39A, Article 32. These are the founding stones of public interest litigation. As I have read out to you the realization of Justice Bhagavat. Very important observation. Even prior to Bhagavat, as early as in 1952, Justice Vivian Bose said this. I'm reading out from the judgment of Supreme Court in state of West Bengal versus Anwar Ali Sarkar. 52 was a great judge so far as constitutional vision is concerned. He said, the law of the constitution is not only for those who govern for the theorist, but also for the bulk of the people, for the common man, for whose benefit and pride and safeguard the constitution has been written. Same thing has been said in a different language of Justice Bhagavat several decades later. Unless and until these fundamental provisions are altered by the constituent processes of parliament, they must be interpreted in a sense which the common man only sees the language, not versed in the niceties of grammar and dialectical logic, can understand and appreciate, so that he may have faith and confidence and unshaken trust in that which has been enacted for his benefit and protection. This is the purpose of fundamental right. This is how it should be read, bereft of all niceties and, as they say, logical paradoxes. This is how it should be read. Hello, has it gone out again?
No, Your Lordship, you are audible.
You're audible.
That is why in PIL litigation, the courts have held standing is not important. Format of the petition is not important. Article 32 uses the expression appropriate proceedings. Appropriate in the context of enforcement of right. That is why it took cognizance of a letter written from distant places. Supreme Court Chief Justice, Supreme Court judges took cognizance and initiated proceedings on the basis of that. Standing is not important, format is not important. The procedural rules like Civil Procedure Code, Evidence Act is not important. What is important is the substance of the grievance before the court. When Olga Tellis, who was a journalist, moved for the pavement dwellers of Bombay, you remember that famous judgment? The Supreme Court stopped the eviction of the pavement dwellers on the ground that from the pavement they are earning their livelihood. Unless you make arrangements for them for some alternative areas from where they can make their livelihood, you cannot evict them in the name of beautifying or modernizing the city. That is one of the finest judgments of Supreme Court. That is also a public interest litigation. The public interest litigation, there have been some abuses in recent terms. in all legal provision there are abuses. Can't be helped. But it's a great instrument in the hands of common man for enforcement of their rights. Otherwise, this code, the constitution, will lose relevance. If it does not mean anything for the common man, for we the people. Because it's a socialist country. What country is this? This is a secular, sovereign, democratic, socialist republic. Therefore, this fight has to be taken on by the lawyers to make our constitution vibrant and inclusive. It's a transformative document. It is from a moribund feudalistic society, India is overnight turned into a democratic socialist republic. But for that, people have to fight. Public interest litigation is a weapon in the hands of the common man to make justice visible, possible, actively visible, and the justice of the widest amplitude. So, as you see, this justice, social, economic, and political is repeated in Article 30. In Article 39A, it said the legal system must promote justice. It will not be just legalese. So this is the basis of PIL jurisprudence, as I see it. Now, if you want to ask me any question, I'm prepared to answer. Because I have already spoken, it's already 6 o'clock. Because of the glitches.
Yes, Your Lordship.
I can take questions now. If the
Thank you,
students-
Your Lordship.
Yes,
It was indeed a thought-provoking lecture, Your Lordship. I'd like to proceed with the questions, Your Lordship.
please do.
The first question is that, Your Lordship, Husainara Khatun versus State of Bihar was the first reported PIL case in India, where a special emphasis was given on protecting the under trial prisoners from inhumane conditions of the prison. Such inhumane conditions are still prevalent. And what might be the reasons, in your opinion?
You see, this Hasinara Khatun's case is not the first PIL. It is one of the earliest, not the first. First, I think, Ratlam municipality's case. It was just Krishna's judgment earlier in point of. Anyway, maybe it is one of the earliest. What was the main theme in Hasinara Khatun? It said that once person goes behind the bar, he does not lose all his rights. He is not denied of his fundamental rights, human rights. He's not a bereft person of all his rights. He cannot be just forgotten just because he's behind the wall. He must be given all his rights in the basic normal amenities of life under Article 21. And it was said so because it was in a case of under trial prisoners. The court found that the jails are mostly overcrowded by under trial prisoners. And our criminal justice system is so slow and time consuming that the trials are not concluded. We are every day confronted with shameful situation, that after say 10 years, 12 years, 14 years of conviction, a person is set scot-free and it's found he is acquitted. He has not committed any offense. How can you bring him back his 14 years of his life? Its time does not stand. Our criminal justice system has to be overhauled. Otherwise, this Hasinara Khatun situation will continue. It is continuing till today because crime is taking place of different description. The crime, if I may say so, the crime profile has changed. The commission of crime has become very complicated. Is all over the place. But the trial does not take place on time. For that, the system is to be blamed. That's my view. The same inhuman conditions still prevail. And it is bound to continue until our criminal justice system is improved substantially. The Supreme Court recently have made very great efforts, I must say, especially Chief Justice E.U. Lalit. He has, during his short tenure as Chief Justice, introduced several strategies to expedite matters. But it has to be done jointly, both by the judges and the lawyers. I feel extremely pained when you find that on the drop of a hat, the lawyers close the court. Shouldn't do it. A court is a mechanism for redressal of grievances. Thousands of poor litigants. To close the court one day means you are closing their redressal mechanism. This is my appeal to the members of the bar. So what is your next question?
Thank you, Your Lordship. Moving on to the next question, Your Lordship. You have been a part of the highest court in India for a period of 3 years and more. Which system of appointment of judges is more transparent in your view, Collegium or NJAC?
Obviously, collegium. Because by NJC, the government is trying to control the appointment of the judges. We have had our past experience. I can tell you, at that time, I was a lawyer. The Supreme Court, immediately after the Keshavananda Bharati's case, appointed a Chief Justice, because then the government had a very major say in the appointment by superseding 3 eminent judges. The sole ground is that those 3 eminent judges, I think Justice Grover, Justice Sjslc, and Justice Hegde, they were senior to Justice Ray, who was appointed. Ray was appointed, but in all the cases, say PVPers case, bank nationalization case, the Keshavananda Bharati case, Justice Ray always sided with the government. He was a judge who was always supporting the government view in important, crucial constitutional matters. And that is why he was chosen ahead of 3 of his colleagues. And all those 3 learned colleagues resigned in protest. That was a black day of the judiciary. Then again, during emergency, I should tell you why I like the collegium system. During emergency, Justice Khanna for the first time said that a citizen has a fundamental right to approach the court even during emergency if he is wrongly picked up under preventive detention. The other 4 judges said no, but Justice Khanna was in minority, but he was the senior most judge in the Supreme Court. And he delivered the judgment, and when he went back home that evening, while he was having tea with his wife and his sister, he said, it is written in his book, his autobiography, Neither Roses Nor Thorns. He has written that possibly today I have delivered a judgment which will cost me my Chief Justice. And it did. He was superseded. So when the power was in the hands of the executive, they have always superseded meritorious judges, straightforward judges, independent judges. They have never bothered to maintain the independence of the judiciary. They wanted their persons, those judges who are having opinion which is favorable to the government, to be appointed the Chief Justice, to be appointed judge. That was remedied by the collegium. If you look at Article 124 and Article 217, 217 of the Constitution is for appointment of High Court judges, and 124 is for appointment of Supreme Court judges. There is no whisper of the collegium system. This is a judge-made mechanism, strategy to ensure independence of the judiciary. Therefore, I support this. The judges are not independent, then the entire judicial system will collapse. You have a strong constitution and weak judges. Because after all, the judges are the guardians of the constitution, of the constitutional rights. We don't have strong, independent judges. Your rights will be just rights on paper. Therefore, I support appointment of judges to the collegium. Yes. Any other question?
Your Lordship, the next question is that the Centre has recently filed an affidavit in the Honorable Supreme Court of India where it has opposed the recognition of same-sex marriage. Would you consider this to be a violation of Article 14, Article 19, Clause 1, Subclause A, and Article 21 of the Constitution, as per the unanimous verdict given in Navtej Singh Johar versus Union of India?
You see, in the Navtej case, it's one of the landmark judgments of the Supreme Court, which is I think, 5-judge judgment. There, the Supreme Court has said that our moral notions cannot decide the autonomy of people. Moral notions, then anathema to the constitutional order, in which liberty must triumph over stereotype and prevail over the mainstreaming of culture. You see, our constitution is founded on a vision of inclusive society, which accommodates all ways of life. And the Supreme Court has said in this judgment that procreation is not the only reason for which people choose to come together or into live-in relationship or marry. So they do it for emotional companionship. So this autonomy which Supreme Court has recognized in this famous judgment, Navtej judgment, is a very important variation, a very important development in the context of person's right to choose his way of life. Supreme Court has said this. With the passage of time and evolution of society, procreation is not the only reason for which people choose to come together. They do so for a whole lot of reasons, including emotional companionship. In the contemporary world, where even marriage is now not equated to procreation of children, the question that would arise is whether homosexuality or carnal intercourse between consenting adults, opposite sex, can be tagged as against the order of nature. Supreme Court has outlawed it. Supreme Court said your personal autonomy, your autonomy over your body can't be interfered with by state. In that context, the stand of the central government in its affidavit, I think it will be examined by Supreme Court, keeping in view the Navtej principle. And I don't know what the Supreme Court will decide, but it apparently looks like an attempt to override or attempt to go sidestep the decisions in the Navtej Singh. You can't roll back the decisions of Supreme Court in Navtej Singh by filing an affidavit. It is of course based on the Honorable Supreme Court to do so. What they will do is their choice. It's their duty to read the provisions consistently with the decided case. Yes, anything else?
Yes, Your Lordship, proceeding with the next question.
Yes.
What are your views on death penalty as a punishment?
You see, death penalty, if you look at the evolution of the law relating to death penalty, which has been the last judgment of the Constitution bench on this, is that the Bachchan Singh's case, where the Supreme Court has stressed the evolution of criminal law, is saying that that section 235(2) of the Criminal Procedure Code, the new edition, which directs the judge to hear an accused on a question of sentence. And when death sentence has to be given, under section 354, subsection 3 of the Criminal Procedure Code, it mandates that special reasons have to be given for death. That means there is a bifurcation. One is the crime which is committed by a person, and the other is how we deal with the criminal while sentencing. The sentencing part is different from the trial and is virtually as important as trial. In giving the sentence, the Supreme Court has said in Bachchan Singh's case, the two principles have to be very carefully judged: the mitigating circumstances and the aggravating circumstances. Apart from the crime, this has to be appreciated separately, so far as the criminal is concerned. And here, though I have not been able to say this, though the crime has to be proved beyond reasonable doubt, in mitigating circumstances, suppose there are 10 mitigating circumstances, or there are 5 aggravating circumstances, if the balance has to be struck, and the mitigating circumstances and the aggravating circumstances here, the right of the accused must be viewed with great caution and care. And the aggravating circumstances against the accused must be proved beyond the measure of any lingering doubt. I could not, as a judge, sort of my brother judge was opposed, I could not put it as a judicial dictum. But as a student of law, I should say that while weighing, mitigating, and aggravating circumstances, the degree of caution by the court has to be higher, and the degree of proof has to be stricter, much stricter. The aggravating circumstances and mitigating circumstances, the balance has to be seen as beyond even any lingering doubt. Even if there is a slightly doubt in favor of which goes in favor of the accused, death penalty should not be. The rarest of rare doctrine must be very carefully scrutinized. And I can tell you as a judge, I have saved from the gallows at least 4 persons. I differed with judges. Ramdev Chauhan is one of them. Where a juvenile was being given death sentence. At least 4 cases. I've deferred, and where it was left to me, I delivered judgment, commuting death sentence to life sentence. Time has come to give a re-look to this situation. Because death sentence, you see, in that Nirvaya case, death sentence was given. Has it stopped atrocities on women after that? What is required is a very quick trial. Very quick trial. Immediate apprehension. Very good, sensitive investigation. And general sensitization and empowering of women. Women are still at the receiving end, especially in the villages. Every day we see even children are not spared. 4-year-old girl, 2-year-old girl, they are not even spared. There's a lot of rethinking. should. Yes, anything else?
Thank you, Your Lordship. Your Lordship, two of our students would like to ask you a couple of questions. I request Mr. Tejas of second year BALLB and Mr. Rohan of second year BALLB to proceed with the same.
Yes, let them come forward.
Your Lordship, I'm Tejas, and my question is about PIL. PIL has evolved to change the judicial outlook and the nation as a whole. However, the approach and easy process has led to the misuse of PIL. Your Lordship, do you think there is a need for restructuring and rethinking PIL?
You see, Supreme Court has, I think, in that Godavaran's case, the Supreme Court has given certain guidelines. I forget the name of the case. Justice Sinha has laid down certain guidelines. The Supreme Court, I think Supreme Court should, I think in many cases, Supreme Court or the High Court has set up a registry where these PILs to be filed are, they must lay down a guideline. I'm absolutely, agreeing with you. And in this matter, the court's time should not be wasted by filing PILs which really has no merit. Which is merely publicity-oriented litigation. This is the vestige of court, the gross abuse of a very valuable right which arises out of the constitutional provision. I appeal to the members of the bar to desist, because it is always the members of the bar who indulge in all this. Desist from misusing this great liberty, which is meant for its proper use. As I agree with you, the abuse should be curbed. Definitely. Any other question?
Good evening, Lordship. Moving on to the next question. Article 124 of the Indian Constitution extensively speaks about the establishment and constitution of the Supreme Court of India. And my concern is about Article 124, Clause 3, Subclause C, which allows the President to appoint a distinguished jurist as the judge of the Supreme Court of India. But this provision has remained inactive for a long period of time. So according to you, Your Lordship, what might be the obstacle for making this article remain as a dormant provision?
It is not dormant, it is not regularly used. Because if you look at the article properly, every judge who is to be appointed to Supreme Court must be a distinguished judge. Must, even if he is a judge of the High Court. All judges, mere seniority will not do. Because he has to take his mission, he will take the Constitution forward. He must be a distinguished jurist in that sense. Not merely 2 + 2 will make 4, that will not do. Because great judge like Justice Krishna has said, a judge in the highest court of this country is not a mere umpire. See the great judges who have taken this Supreme Court forward, like Justice Krishna, Bhagavati, Justice Chandrachud, I'm talking of the father. This present Chief India is also good, very good. They came from the bar. Justice Khanna, all came from the bar. This is Bijan Mukherjee, they all came from the bar. This is Vivian Board. Because you see, a jurist has more or less a theoretical. You have to fashion your judgments which will meet the problems of the day. Every case, every situation presents several problems before the court. And you have to settle the problem, settle the dispute effectively. Mere theoretical knowledge will not do. But at the same time, you must have a vision to change them. The judgment in the given by Supreme Court in the Navtej Singh's case, the great fact, one of the finest in the history of Supreme. Mostly by judges from the bar, and one of the judge was Justice Nadiman. He was chosen from the bar, maybe in the category of a distinguished jurist. He was not a judge. But unless you are associated with the bar, associated with the daily business of justice delivery system, dispute resolution, mere theoretical knowledge in the classroom will not do. This is what I'm saying, telling you from personal experience. So therefore, this provision has been used, but not regularly. It has to use the sense of moderation. That is how it.
Thank you, Your Lordship. Moving to the last question. What would be your message to the students of law?
Well, what would be my message? I've already said. While explaining the principles of PIL, I've already said. It's a fight, it's a crusade for justice. The students of law, the greatest crusaders for justice, they understand the concept. They understand the distress of the people who are denied justice. Constitution promises, but the common people, we must be seeing every day, the common man is denied because there is no legal literacy. If there is no normal literacy, the legal literacy comes later. They are not aware of that. They do not know how to go about. Therefore, my message, if I may say so, instead of joining corporate houses, join the profession, serve the common man. Many young lawyers these days, after they finish their courses, join corporate lobbies. Don't do it. Have a much wider field to traverse. Much more important role to play. I'm not saying corporates are not doing good work. They are doing, but you have a wider, much more open, much more independent, much more inviting, and much more enterprising. If you call that that is my message to young budding lawyers. You may not be assured of a very decent income every month, but you have to fight with people, make them realize the right. This legal aid movement, various other movements the court is now launching. In that you can play a positive role. Make it really vibrant. The Constitution must mean something. Can you tell me what it has given to every common man? Constitution. Without asking for it. It is given to every common man. Constitution. Tell me what it has. To every common man, however poor he may be. His right to vote, right to participate in democracy. Whether you have 1 million in the bank account and the person, the rickshaw puller, may have 10 rupees. He has one vote, you have one. That's a great feature of the Constitution. People must realize the importance of that vote. Most of the people don't realize, don't exercise. They sell their vote for nothing. They don't exercise it. They think, क्या होगा देने में, क्या फर्क पड़ेगा? It will, it's meant for bringing about a change. Make them realize the importance. That is what Ambedkar has said. Politically, they have the same value. That is what the Constitution has at least done, achieved. Politically, the richest man in India and the poorest man in India has the same value. They must realize this. But socially and economically, there's a huge gap. The gap has to be bridged. That is the message of the Constitution. It's not being followed in most of the cases. It's for you to bridge it. This is my message to the students of law. And these law students understand it better, best. They read it. They are confronted with the actual situation. Your duty to bridge. Very difficult, but not impossible. Anything else? Any question?
Thank you so much, Your Lordship. JSS Law College Autonomous and the Neeti Forum is grateful to you for having graced the occasion.
Thank you.
I now
very
call
much.
upon.
Thank you very much.
Welcome, Your Lordship. I now call upon Mr. Antriksh Kodandara to render the vote of thanks.
Thank you, Pratyush. Good evening, delegates, teachers, and team members. I'm Antriksh Kodandara, and I consider it a pleasure and privilege proposing a vote of thanks on behalf of the Neeti Forum, JSS Law College Autonomous. Honorable Mr. A.K. Ganguly, former judge of the Supreme Court of India, interacting freely with the participants made this day a truly insightful lecture to treasure. We offer our sincere thanks to you, Your Lordship. Any program works with the precision and poise, and all that is simply made possible by the vibrant and dynamic leadership of our Chief Executive, Professor K.S. Suresh. Our heartfelt thanks to you, sir. Our beloved principal, Dr. S. Nataraju, always gives us his valuable guidance and moral support in organizing events like this. And on behalf of the Neeti Forum, let me please offer a sincere thanks to you, sir. This success was only possible with the synergy created by the assistant professors and faculty coordinators who constantly guided us with all their total support, and thanks would be too little to offer. Kindly accept a sincere thanks. I offer my sincere gratitude to all the members on this committee for their dedicated involvement, cooperation, and managing things end to end. My final thank you to the audience for their disciplined presence, participating wholeheartedly, and making this webinar a success. Until the next learning initiative, stay safe, keep learning. Thank you all. Thank you.
Thank you, Your Lordship. Thanks.
Sorry for the technical glitch.
Okay, it's okay.
Not me, it's in my hands.
Yes, sir.
Thank you. I enjoyed it. I enjoyed the interaction with the students and all that. Thank you very much for giving me this opportunity.
Thank you.
Thank you.
All the best.